Number 91, Howell v. City of New York.
Good afternoon, judges. May I please the court? Beverly Veneer with law firm Gary Rollins for the appellant Dora Howell. We are here in a matter wherein we believe that the court must reverse this matter and remand it to the Supreme Court.
Mr. Evanier, did you want to reserve any time for rebuttal in this case?
5 minutes, please? I apologize.
5?
Is that too long?
It's your choice. 5 it is.
Is 3 good? I don't know. I'm just, whatever is the standard, I'm fine with that. 3 minutes.
You have 3
I
minutes.
apologize. Yes, we believe the case must be remanded as there are issues of facts in the matter. We can address the first, which would be under the Domestic Violence Intervention Act authorized, we believe that authorizes a private right of action here because in this matter.
Did you preserve that argument below?
Yes, in the complaint we did, and in the appellate division response and decision, that was addressed, it was acknowledged, but it was dismissed. And that was with oral argument only by the City of New York. Dora Howell was not permitted to and did not have any notice that the matter was on for oral argument. It was only to be acknowledged or to be decided on the actual motions. So the fact that the city alone was able to argue oral arguments in front of the appellate division, that's obviously another matter, but yes. In the Supreme Court case, the city brought an action for summary judgment. And at that time, the court said, it's too premature, we don't have enough evidence, because at that time, we didn't have any other discovery except for the deposition of the plaintiff. And of course, the record, which is the 8 orders of protection that the plaintiff sought, and the fact that and these were not contested facts, and the fact that the police officers within a week responded 4 times to the residents, and none of those 3 times prior to the actual incident that they arrest.
Right, but how about that the
Asking.
statute itself?
The statute itself mandates that when
But that the statute itself established the private right of action. Did you argue that below?
well, in terms of the complaint with the Supreme Court, and, well, that time in the Supreme Court, we wanted more information. We wanted information regarding the negligence of the police officer, the municipality, and in terms of whether or not they had proper training. We didn't know that. They did not provide that. We were wanting to depose all 4 of the police officers. We did not have that opportunity. So that's why at that time, the lower court said it's premature. You have to go back, and you have to now complete discovery. And that was not done. So instead, the city ran to the appellate division and asked the appellate division to reverse, saying, based on Mrs. Howell's testimony, that was sufficient to not show that there was a special duty and/or negligence in terms of violating the DVIA, the intervention. I'm sorry, did I answer your question? Do
Yeah,
you want me?
you can proceed.
All righty. So yes, we do claim because of the orders of protection and the fact that the city with the police officers had a relationship with her, knew of the existing harm that could threaten her, that Domestic Violence Intervention Act authorizes a private right of action. And in that act, it states that the police must arrest. It's not discretionary. They have no choice. And in this case, they did not arrest. They never arrested him. The first time she called, they came when he's banging her door with an iron pipe. They came and they escorted him to walk around the block. The second time, they called, I could be mixing up, but one time they called his uncle or a relative that allegedly has some relationship with either the police officers that responded and the police department.
Is your argument here that a cause of action arises out of the failure of the police to arrest Mr., what's his name, Garvin?
Yes, Gaskin.
Gaskin, excuse me.
That's okay.
That's a...
That's one of the
That's a
arguments,
claim
yes.
here?
That's one of the arguments, yes. And
Wouldn't that be sort of the ultimate discretionary governmental function, whether to arrest
well, no,
somebody?
but because this is a domestic violence situation, that statute in 1994 says that that
So
the
this is
police
a
officers have no-
statutory,
This is
of
statutory
action.
and it's case law, right?
Okay.
Because Curry talks about that, Cuffey, I apologize.
at the risk of repeating a question
course, no.
you already answered, do you believe that the statute that
Requires
the arrest gives a private right of action to a plaintiff such as your client?
Is not only my claim, not just the fact that they have to arrest, it's because of the orders of protection and the fact that there's a relationship that is detailed in Ferreira that the court just decided on, that
There's a
is,
private right of action there?
yes.
Can you explain how that arises?
That arises, maybe I'm not making myself clear, that arises because we have the plaintiff having a direct relationship with the police officers. The two police officers here responded at least 2 times to Mrs. Howell home. She had in Ferreira, it talks about the prongs that are set up for the right of action, and the reliance is not necessarily, it's not necessary to be met as there's one of the 3 prongs. It's either or, it's not and. So yes, we submit that even if you want to argue all, then yes, there is a reliance based on the history that she's had with the police officers, with the fact that she sought and received from the judge 8 orders of protection, and the fact that they are aware of Gaskin's, the police officers, the municipality, are aware of his violent behavior because they've had proof of that violent
There
behavior.
were some other things that happened in this case, on the record that I read, such as the police came to her and told her she should move somewhere else.
Well, that's not really feasible in Brooklyn, New York. It's just not.
I get it.
Yes,
I
mean,
don't live
it's-
that far away from there.
It's not feasible. That was not very
They
smart.
also told her, if you call us again,
They're going to arrest you.
we're going to arrest you.
Yes, they threatened her, and she was terrified.
Yeah.
She was petrified of what happens, because she knows, she's aware of the fact of what happens
If a
to
cop
women
said something
in
like
Rikers
that-
Island.
You know, that would be the kind of thing that you would take to mean, or one could take to mean, I can't rely on the police to offer me any help here. They're not going to offer me any help. I'm completely on my own.
But she has no other recourse, except if you wanted to have vigilante
But
justice.
I think, counsel,
Yes.
if I could maybe rephrase it, a traditional case like this, the terrible fact patterns, we see police come and they say, don't worry, we're going to arrest your significant other here.
Right.
Like, they'll be in jail, don't worry, the person stays, there's a horrific event. In this case, it seems, I think what Judge Canatero is getting at, almost the opposite. They tell her they're not doing anything. They tell her they're not going to take any action. In fact, the allegations are, as you said, of their behavior. So what could be the reliance on that that's comparable to the reliance on, we're going to arrest your...
And my argument is that that reliance prong does not have to be met if the first prong is met, which is that the law mandates and that the police officers must arrest when there's a domestic violence
So
matter.
that would be the private right of action?
Correct.
Okay.
There's a private right of action established when you can show that there's a special relationship between the defendants and the plaintiff, which in this case, they've been established that there's a special relationship.
But just correct me if I'm not understanding you. Is your argument also that that special relationship created by the statute gets you out of the Cuffey factor of justifiable reliance, or is it a separate argument that that creates a private right of action?
Well,
Or both?
there's both and some. Okay, I'm going to clarify. In Cuffey, which is more clarified in the Ferreira matter, wherein this court said that the plaintiff must show either of the prongs, must show the relationship or the detrimental reliance. It's not all of the prongs that must be met in order for this matter to be, in order for the private right of action to be met, that requirement or that right to now bring a lawsuit against a municipality.
Thank you, counsel.
May it please the court, Devin Slack on behalf of the city defendants. So plaintiff presented neither of her merits arguments to Supreme Court. Under Hecker v. State, that's the end of this case. Now in the appellate division, plaintiff did present a Cuffey-like argument, but it's different than the one presented in her opening brief. It sounds more like the one we heard today. The one in her opening brief is, when she left,
Plaintiff did allege special duty in the complaint, though, right?
she alleged that she was given assurances of continuous police protection.
Never said that she was owed a special duty as an allegation in the complaint?
Oh, I think that was part of it. It was a traditional Cuffey-like allegation.
That's my point. It sounds like a Cuffey cause of action is being pled in the
Correct.
complaint.
Correct. And then in the opening brief to this court, we get the opposite, where the plaintiff claims that she felt she had to protect herself.
Well, there is another argument, I think, in the brief in our court, which goes to the question that Judges Garcia and Canataro were asking towards the end, which is that a trier of fact could conclude that when the police said, if you call us again to complain about this, we're going to arrest you, that was their way of saying, the reason you're calling us and making us come here is provoking this. And if you don't call, then we've got the situation under control. Is that a triable issue?
I think that might have been the argument that the appellant presented to the appellate division, but not Supreme Court, where she argues that she was told to follow their directives. But it's definitely not what's in the opening brief here.
Don't call us, don't call us again as a directive.
Yeah, no, I agree. In the appellate division, I think there might be an argument that that was what she was saying. Here she says quite clearly she felt she had to protect herself. It's the opposite of reliance. She says she was not relying on police
That was
protection.
the argument here. What was the argument at Supreme? What is the preserved argument?
There is no preserved argument. The only argument that was made in Supreme Court was that she needed more discovery. That argument does not appear in the opening brief in this court, didn't appear in the leave motion as far as I recall, but it definitely isn't in the opening brief to this court. No merits argument whatsoever has been preserved under Hecker. Even if you look only to the appellate division, there was no argument on the statutory duty question. The key issue, there was absolutely no argument that the DVIA authorizes a private right of action. Zero. And her Cuffey argument was not the one presented in the opening brief, where now she says she had to protect herself.
Well,
It's a
what do you take to be, under our liberal pleading standard, the appropriate reading of the complaint?
I think the reading of the complaint
Yes.
is that a traditional Cuffey claim, that she was granted assurances of continuous police protection, which she disclaims in this court, where she says she was told, I couldn't rely on them, basically. I had to protect myself. And again, no
Police
arguments.
protection because she had an order of protection?
I think that's probably the most that we get out of the complaint. There are,
Well, why isn't that about the statute? Since the statute mandates particular conduct, if one presents an order of protection or has an order of protection, if the police can
Sure.
discern that you have an order of
sure,
protection.
I mean, it has a vague connection to the statute. The
Well,
statute
but we
wasn't
have liberal
mentioned.
pleading standards, so, and we have to give
Sure.
all of the best inferences to the
Sure,
plaintiff.
and we're not talking about just pleading standards, we're talking about preservation. No
Yes, but
no argument
to
made.
preserve, you got to plead, right? I mean, that's the point.
That's the starting point.
That's the point.
No argument on statutory duty in Supreme Court. In the appellate division, no argument on whether the DVIA authorizes a private right of action. Let me just turn to that for a second. You know, there's abundant evidence just turning to the merits, abundant evidence that the legislature did not intend to create a private right of action under subsection 4 of 1410, which is the relevant part of the DVIA here, including statements from the Senate sponsor that I wish we'd flagged in our brief because they're extremely illuminating. They speak directly to this question, and I just think the court should be aware of them. Asked specifically whether this provision would make officers liable for failing to make mandatory arrests, the Senate sponsor said, and this is starting an exchange that starts on page 5631 of the debate transcripts, that there is nothing in this bill that deals with, in any way, shape, or form, any effort to expand municipal liability. Another quote, we are not adding any liability. Now, that's about as clear a statement as legislative intent as you're going to get. There are several other indications that lead us to the same place. It goes
Then why doesn't that end up in the statute itself? If it's that clear, if that position is one that the elected officials who voted on this felt strongly about, would we not anticipate that it would be in the statute?
As far as I'm aware, this
I
court...
mean, if they're that concerned, of course, as I'm sure they would be about the potential price tag, if you want to put it that way, the cost of this, the potential liability, one would think they would have made very clear about it, as clear as they are in those statements that you were saying show that.
As far as I know, the legislature is not in the habit of specifying that there is no private right of action. It does
Well,
it
they
sometimes.
do say, no cause of action for damages shall arise in favor of any person by reason of any
Correct.
arrest, et cetera, et cetera. So actually, for this statute, they were aware of the potential for some type of litigation.
Exactly.
Why not say you can't sue anybody for anything?
So that's actually I mean, there's this, actually, if anything, that cuts in our favor. Because it shows that the legislature did bring its judgment to bear on the question of civil liability, and rather than authorize private rights of actions for failing to make mandatory arrests, it immunized officers for making good faith arrests.
Doesn't the fact that they had to say that assume that there's otherwise a private right of action?
No, and
That's
actually,
why they have to make this carve-out?
not at all. And in fact, this court has rejected that kind of negative implication in
Okay.
3 different occasions. And if you look at that exchange I'm talking about on 5630, it's actually it was occasioned by this provision, and it was very clear, we're not adding liability, we're also not taking any
But
away.
you can't, the provision, I'm just responding to what you're saying and asking you about that, but the provision you're in some ways can't really be taken in isolation given the rest of the statute, right? The rest of the statute is very clear of the tremendous impact of interpersonal violence on families, but of all the members of our diverse communities, both on the civil and criminal side. I mean, civil is mentioned many times throughout the statute. So it's hard for me to really fully appreciate, let me put it that way, your argument that somehow the legislature, given the history you're pointing to, really didn't want to get sued, didn't think that was a good thing, carved out a particular class of suits, but didn't say anything else, even though it's recognizing the tremendous adverse consequences of interpersonal
Sure.
violence, not only on individuals, but on the community
Sure.
at large.
Well, I'm just going to set to one side that the Senate sponsor expressly spoke to this and said that there was no municipal liability. Very clear about that.
Okay.
I'm also going to set aside that this kind of negative implication from an immunity argument has been rejected by this court on 3 occasions.
Are you talking about Mark G. or something else?
I think there were 3. I think it was in Cruz, Mark G., also might have been v. East Greenbush. But repeatedly, that kind of negative implication. And that was in situations where we didn't have express statements from legislatures saying that this provision is not meant to create municipal liability. So I would just go to all those other avenues, just goes to show that the legislature in this integrated bill that covers 50-plus substantive provisions contemplated a range of enforcement mechanisms to achieve its goal to ensure that domestic violence was reduced by holding offenders accountable. Even if you look only to subsection 4.
But this is about holding law enforcement accountable, which is very clear in the statute and very clear in the advocacy up to the passage of the statute, was of significant concern, right? That unfortunately, it's hard to believe that in the years we're in, that officers, assuming, as we must, facts are all true, that officers said and did what happened here. That the legislature was concerned. That's why you got the mandatory
Absolutely.
arrest, right? That is what
Absolutely.
they're concerned with.
Subsection 4 is itself
So-
a mechanism for ensuring that offenders are arrested and
Yes,
held
that the
accountable.
abusers,
Not-
abatterers are taken care of, but the point is, the mandatory arrest is also because of the well-documented failure of law enforcement
Right.
to arrest.
And the point of it, and you see this in legislative history, in the sponsors memorandum and in the debates, was not to impose liability on officers, it was to remove their reluctance and to make it clear that they had no duty to mediate in the context of domestic violence. But even as to subsection 4, the legislature could not have been clearer about what its enforcement mechanism was. It was political oversight.
Can I just ask you, moving away from that for a minute, because this mandatory arrest might go under governmental function immunity as well, right? I mean, I think that analysis is better suited for that. But regardless, if we adopt your position under the assumption of duty, aren't we incentivizing police not to answer calls of women who are in need?
No, not at all. I mean, the officers still have a mandatory duty to arrest that's subject to
Well,
political
we're saying you
oversight.
can't justifiably rely on them because they're not going to do anything to help you.
No, not at all. There could still be a cuffy claim if we're turning to that. But if it's a statutory duty question, it's a question whether the legislature intended to authorize it. The legislature was very clear. It was a pilot program covered with a
Yeah, I'm not
coupled with a
talking
training
about the
regimen.
statutory. I'm talking about another way to prove special duty, right, is an assumption of duty by the governmental entity.
Sure, in like a cuffy context.
Yeah, so now I'm saying to you, if we're going to argue here, which I think you did argue, that Miss Howell shouldn't have relied on those police officers because they basically told her, we're not making an arrest, there's nothing here for us, go move. So if she can't rely on them, right, what are we saying as a society if we say, are we incentivizing police not to answer those calls?
No, I don't think so. I think this is like a very particular part about this very unusual case. I think on one part it's about plaintiff's disclaimer in her opening brief to this court that she was relying on police protection, that she felt she had to protect herself. Even if you back up and go to either the complaint or her testimony at her deposition, she still wouldn't even satisfy the traditional test under Cuffey. She said
Okay, but how do you
repeatedly,
distinguish Mastriani?
Mastriani in a few ways. I mean, one, I think the most important thing to take away from Mastriani is that this court said that an order of protection, and this is well after 1444 had been enacted, is not sufficient by itself to establish justifiable reliance. The other thing, Mastriani, the officers were on the scene. They parked across the street. They
Correct, but
stayed
that's what I'm
there.
saying. So when the officers do something which would have someone rely on them, when they're taking some affirmative action, we're saying, okay, you've relied on that, and now you could, you satisfy that prong. In this case, we're saying if you do nothing, right? If you do nothing, then there's no reason for you to justifiably rely. So I'm just saying that intuitively, that really makes no sense.
I think it's the unusual situation where the plaintiff has made contrary allegations as to whether she was relying on police or not, and it's difficult for me to really wrap my head around
But if
those.
the statute mandates an arrest, shouldn't it be inferred that one would rely that the police are going to protect you? Statute says arrest, it's not discretionary anymore.
I mean, this court's rejected that on two occasions, in Mastriani and in Soricetti. In the court's two most recent cases, special duty cases involving order of protection, the order of protection played essentially no role, and it didn't play any role in
Can she
justifiable
hope that the next time
reliance.
she calls, it'll be different officers who don't have this, I'm
sorry?
not going to arrest state of mind?
I'm sorry?
Could she have hoped, or someone in her position have hoped, that different officers might answer her call the next time?
Possibly. I mean, there were eight different occasions allegedly, and Mr. Gaskin was
So
arrested on three.
the statute was enacted for nothing. It doesn't mean anything.
Well, I think it's absolutely true. Well, so I guess one thing that I could say that's not in this case because of the statute. It creates a mandatory, at least in the order of protection text, a mandatory duty that would not be subject to discretionary governmental immunity, the professional judgment rule. We're not talking about the professional judgment rule. We never relied on in this case. We're talking about a special duty. And plaintiff has identified two avenues. There's the statutory one. It is incredibly clear for 7 or 8 reasons, including direct statements by the Senate sponsor, that the legislature had no intention of creating a private right of action under that. And plaintiff's allegations, whatever theory you want to take, neither of them are preserved.
So
If it's a
given that the
traditional-
legislature was so concerned about law enforcement failure in this context, what else is set up to ensure that law enforcement does its job?
So it started with a pilot program,
Yeah.
coupled that with training, and it required 2 state agencies to report to the legislature and the governor on an annual basis.
Okay.
It's political oversight. And ever since, subsection 4 has been subject to a sunset
And it didn't work
provision.
here, so what, if we go down to this micro level, what, is it the CCRB, what is there in place to address the problem that happened here? Because obviously, those things are in place and they didn't do a thing. So what happened
I
here?
think that question is one that should be directed to the legislature, not this court, because the legislature has continuously decided to make subsection 4 subject to a sunset provision. It has rejected proposals to make it permanent. So it has had to re-up the provision every 1 to 2 years or it comes off the books. And it would be incredibly strange to think that the legislature authorized a private right of action for 1 or 2 year periods.
Thank you, counsel.
Thank you.
Now, I want to first address I apologize. The interview, I believe you mentioned a transcript that was not on the record, and that is regarding the senators' back and forth regarding what the private act, I apologize, whether or not a person has the private right to have a lawsuit against the government. In that interview, if I'm correct, because he literally just emailed that to us yesterday, it indicates the senators, I believe, did not want to answer the question directly. They essentially said, we're not changing anything. However, we are saying that if there is an arrest, which is mandated, then you have no private right of action. But they don't speak about whether or not, in this case, whether there's not an arrest. They're trying to gauge the senators.
You mean the references to what already exists in the statute?
Correct. Now, what the senators, the city's relying on is that the senators did not discuss directly whether or not, if there is no arrest as mandated, whether or not there's a right of private action. And one of the senators, I believe, Boland or Saland, I believe, if I'm correct, indicates one is, if there is no arrest, and I'm paraphrasing, then it is a gross negligence on the part and/or gross wanton negligence. This is in the, let me reference it correctly. This is the dialogue between Senator Dollinger and Senator Saland, okay? And this is what I believe the adversary is speaking about, which is on page 5632. On that, it's the Senator Saland, this is what he says, they are basically intended to make it clear that the obligation or requirement of mandatory arrest also clothes the officer with immunity, which is under CPL 140, that they are acting according to the responsibility of their office, acting in good faith and not grossly or willfully negligent, and that in essence in those several sections, we are not taking away. So they're saying they're not taking away any liability, but they're saying that you have to make the arrest. And if you don't make the arrest, there is an open case for a person, a private party, to bring a case against the city or the municipality. I just want to reiterate that Ms. Howell was mortified about going to jail. She did exhaust all the remedies in terms of calling the police officers, getting the 8 orders of protection on different occasions. And yes, she relied on them, on the police officers, but she also understood that they told her directly not to call us, or else we will arrest you. They actually threatened her that they'll arrest her in the 3rd time. They never arrested Mr. Gaskin. So I don't know.
And at a minimum, she relied up till that moment, right? Up until, at a minimum. Let's just
At
put
a
aside,
minimum.
let's put aside at the moment that the officers say, just don't call us, or we're going to arrest you. Before that, she completely relied on them.
Of course.
She kept calling them.
She kept calling them. And, but again, the adversary is misrepresenting the facts here. It's not contested, it's totally uncontested that they did tell her not to call. They did tell her they will arrest her. There was no ambiguity about it. There is the reliance based on the factors that they knew and had a relationship with Gaskin's relative. every time they told her they would arrest him, she would know, and again, this is not contested, she would see that they were having walk around the corner. And the second time that the uncle picked him up and drove him away. So therefore, Mr. Gaskin had no reason to believe there were any consequences or repercussions for him going back there again, for him going there and dragging her up the third floor and hurling her outside.
So you're saying even they're coming and taking him away from the premises, that wasn't enough because they didn't
Arrest
do
him.
that which the statute required, which was arrest?
Correct. They never arrested him, and they had at least 3 occasions prior to this incident to do that. And then in the third occasions, when they told her, don't call, don't you call us, we will arrest you. That is, again, not contested. That's unconscionable.
Thank you, Counselor.